Hello, this is Georgia Attorney Drew Mosley, and I am talking today about criminal history record information. And this is Official Code of Georgia Annotated 35-3-37, as I've written on the board. And Title 35 of the Georgia Code deals with law enforcement officers and agencies. Chapter 3 deals with the Georgia Bureau of Investigation. And Article 2 thereof deals with the Georgia Crime Information Center, which some refer to as GCIC. I'm going to start with the definitions for this code section. As used in this code section, the term 1. Drug Court Treatment Program means a treatment program operated by a drug court division in accordance with the provisions of Code Section 15-1-15. 2. Entity means the arresting law enforcement agency, including county and municipal jails and detention centers. 3. A mental health treatment program means a treatment program operated by a mental health court division in accordance with the provisions of Code Section 15-1-16. 4. A non-serious traffic offense means any offense in violation of Title 40 which is not prohibited by Article 15 of Chapter 6 of Title 40, and any such similar offense under the laws of a state which would not be considered a serious traffic offense under the laws of this state if committed in this state. And watch this again if the definitions are not clear on the first pass. Some of them are a bit dense. 5. Prosecuting attorney means the Attorney General, a district attorney, or the Solicitor General who had jurisdiction where the criminal history record information is sought to be modified, corrected, supplemented, amended, or restricted. If the offense was a violation of a criminal law of this state, which by general law may be tried by a municipal magistrate, probate, or other court that is not a court of record, the term prosecuting attorney shall include the prosecuting officer of such court, or in the absence of such prosecuting attorney, the district attorney of the judicial circuit in which such court is located. Restricted, restricted, or restriction, this is number 6, means that the criminal history record information of an individual relating to a particular charge shall be available only to judicial officials and criminal justice agencies for law enforcement or criminal investigative purposes, or to criminal justice agencies for purposes of employment in accordance with procedures established by the Center, and shall not be disclosed or otherwise made available to any private persons or businesses pursuant to Code Section 35-3-34, or to government agencies or licensing and regulating agencies pursuant to Code Section 35-3-35. 7. A serious violent felony shall have the same meaning as set forth in Code Section 17-10-6.1. 8. A state includes any state, the United States, or any district, commonwealth, territory, or insular possession of the United States and the trust territory of the Pacific Islands. 9. Veterans Treatment Program means a treatment program operated by a Veterans Court division in accordance with the provisions of Code Section 15-1-17. A youthful offender, number 10, means any offender who was less than 21 years of age at the time of his or her conviction. So those 10 definitions are what begin this code section and begin to lay out what record restriction is all about in Georgia, at least to the extent described. So I'm going to cover the remainder of the statute in additional videos. This is recently amended. This section was revised, and this is effective as of July 1st, 2016. So it's recently been updated.